in CAP 253, and that is its mandate to conduct inquiries. It regulates professional conduct. It ensures fitness to practice. It can go into what the Constitution calls alternative dispute resolution mechanisms, key among them being mediation and arbitration. And this is just to allow for faster resolution of complaints. So you don't have to go through the rigorous process of courts. You can actually have parties, whether a patient and a doctor, sit together and decide, you know, this went on, but we've settled. And that mediation agreement can be adopted by the council. This is also just in the act, just showing what this committee can do. It goes into issues of breach of standards. It looks into issues of professional misconduct with regards to breach of standards. It ensures that, as per Article 51 of the Constitution, is that you are heard. So if a patient complains against you, you do have a right to be heard. So you're not condemned unheard. We also, that committee administers oath, and we don't usually follow the rigorous processes of the courts. We regulate our own procedure when it comes to disciplinary proceedings. With regards to the sanctions that can be given, we can either issue a caution, we can direct that you go remedial training if you feel that there's something that's missing. We can place you on probation for a particular period of time. We can either, if you're a practitioner, your license could be suspended, could be withdrawn or canceled. If it's an institution, same for that, your license could be suspended, withdrawn or canceled. Maybe the whole institution or part of the institution. The most severe penalty is removal of the name from the register if you're a practitioner. And the council now can also impose a fine against a practitioner or institution. This one is just addition. If you want to appeal a decision of the council, you have to do so within 30 days of that decision. Now, I want to go straight now to the substantive matters of my presentation. I'll begin with a story. A story is told of this lady who, at some point, her child fell very sick and she was living in a rural area. So she had to travel far and wide to get to this main hospital. And she traveled probably most of the night, and she arrived there at about 1 a.m. in the night. And she was very tired. And the son was admitted to hospital. And in that room that the son was admitted, she had a sofa which she could sit and squeeze herself and get some sleep. But every turn that the son made, the machines that had been hooked on him would go off and make blaring noises. So one of the nurses felt sympathetic for the mother because she was really tired. She had traveled for a long distance. And she said, let me see if I can allow this woman to get some sleep as the son is there on the hospital bed. So she turned off some of the, not off, but she turned off some of the alarms in that room that were monitoring the son. Now, I want to stop there for that story. I'll continue at the end. And let me go now to the presentation. Medical error. This will be what my presentation outline will be. What is a medical error? How common are medical errors? Issues surrounding medical error disclosure. Should you disclose or not? Should you hide behind and cover? Medical errors and the legal liability, the dilemma that this puts you in, and what should be done. So what is a medical error? It is a form of what we call an iatrogenesis. An iatrogenesis refers to any effect on a person resulting from any activity of one or more of persons acting as healthcare professionals, promoting products or services as beneficial to health, which does not support the goal of the person affected. In short, this just means negative effects brought forth by a healer. So it is something that is brought, something negative that is brought upon you when you actually go to someone seeking healing, and they actually don't give you healing, but they actually give you pain and suffering. Unlike an adverse event, an iatrogenic effect is not always harmful. I'll explain that further. For example, you may go for surgery, you get a scar, that is categorized as an iatrogenic effect, but does that really mean it's tantamount to medical negligence? No. It is just that it might not represent improper care and might not be troublesome, but it's a negative effect or an adverse event as a result of a medical procedure that you've undergone through. Cases of iatrogenesis, they may include side effects of possible drug interactions, use of contaminated instruments, complications arising from medical procedure or treatment, and the focus of today will be medical errors. Also, there could be unnecessary medical treatment resulting from a physician's decision. A medical error is preventable, meaning there are certain preventive measures that can be put in place to ensure that medical errors do not take place. That's why there are SOPs to ensure that you are actually doing things as per the guideline and you do not necessarily just depend solely on your reasoning and just your thinking and what you're doing, because sometimes when you're doing so many procedures, the risk of making an error, a mistake, is high. So that's why we have checklists. That's why we have pre-op checklists and post-op checklists, just to ensure that you don't forget. We don't leave it to the devices of man to ensure that things are correct. We lay them down in procedure. Medical errors are differentiated from medical malpractice in that the former are regarded as honest mistakes or accidents, while the latter is a result of negligence, ignorance, or criminal intent. I would just like to repeat that. Medical errors are differentiated from medical malpractice in that the former are regarded as honest mistakes or accidents, while the latter, that is medical malpractice, is as a result of negligence, reprehensible ignorance, or criminal intent. Types of medical errors are diagnostic. You can have medication errors, surgical errors, not just because of negligence, but surgical errors that do happen and it's an honest mistake can happen, equipment errors, or laboratory errors. Now, usually in the medical field, I know we usually have code words for some of these issues, and just to maybe bring them forth to see if this sounds familiar, there are code words for medical errors that medics in the field use. They'll say, oh, there was an adverse event or adverse outcome, medical mishap, therapeutic misadventure or bad call, sentinel event, or hospital-acquired complication. Those are some of the code words that are used for medical errors. How common are medical errors? In Kenya right now, we don't have quite vast data with regards to medical errors. So this is actually a big gap that probably some of the organizations dealing with this, including the council, can be able to look into and see how common are medical errors. Not medical negligence, not medical malpractice, but medical errors, honest medical errors. Statistics globally show that in the UK, it showed that it was an estimate of 850,000 medical errors occurred each year. And that about 44,000 to 98,000 deaths that were preventable actually occurred because of medical errors. Globally, in 2013, from a study, it was estimated that 142,000 people passed on because of medical errors. And that even the US, there you can see that in 2016, they estimated about 251,000 people passed on as a result of medical error. So straight to it, should you disclose? If you're a doctor and you're there and you've You know, when you're prescribing the medicine, you probably wrote the wrong one and not the proper one. Or you wrote the wrong dose. Should you disclose? Should you keep quiet? Should you just sit and wait to see if anything will go wrong? As healthcare continues to be commercialized, I just want to say that there seems to be a bit of a disconnect between, especially in the doctor-patient relationship. There's this conveyor belt mentality where patients are just seen as products on a production plant, where it's just about how quickly can I get as many patients off my list. And it's understandable in this world where targets matter, uh, time is constrained, resources are limited. Even if you didn't want to be that kind of a doctor, it's understandable how the situation could fix you into that. So as a result, with the litigiousness of these issues, especially as we've seen in Kenya with our new constitution and people being enlightened about their rights, a lot of medics have developed the deny position, where they feel that if they disclose, they are going to actually put themselves at risk of litigious processes. But I'll go into that a little bit more. With regards to disclosure of medical errors, according to a study, it shows that generally found that patients want to learn about all medical errors, regardless of the severity. They want to learn how and why the mistakes happened, and they're concerned about the preventive measures that the hospital or the practitioner will take in future to ensure that such mistakes do not happen. And there's also that emotional support and the empathy that, you know, if something has gone wrong, you empathize and you just don't, again, treat them like a product on the production line in a factory that, okay, I'm done with you, move along, go ahead, you're no longer my problem. The situation, it's noted that most practitioners and hospitals don't reveal their medical errors. The standpoint is to deny the situation because they fear that their reputation will be damaged or they'll be subjected to litigation. And it has been shown that professionals are less likely to disclose if actually there's preventable harm to patients. And the question is, should you do that or not? I know it's a very sticky situation. You don't want to implicate yourself. It's human nature to try and defend yourself. But what should you do? Considering that there's an asymmetry of information and power between you and the patient. You have more power, you have more knowledge. You're the one where the burden of proof is actually placed upon for you to ensure that this person becomes well, and if anything goes wrong, it is in your hands. There's a denied defense mechanism. I won't go deep into that, but I've spoken already on that. Regardless of severity, like I had said, patients want to be informed of the errors. Patients are less likely to sue if the doctor discloses the error than they would if the error is discovered by other means. There are times here at the council when someone lodges cases, and their main issue is this doctor didn't even say anything. He's never called me since that day. He has never even bothered to say, I'm sorry. I just wish this doctor could call and say that I am sorry, Mr. So-and-so, I'm sorry, Madam So-and-so, for this happened. And if that doctor said this, I wouldn't even lodge this case. But because there's the deny perception and stand, because this patient is really hurt about what has happened, it becomes a bigger thing than it would have initially been. So, medical errors and legal liability. This is the dilemma that this places you in. If you recognize there's a medical error, should you keep quiet or should you disclose? Again, what do the patient want? For many studies, it has shown that patients' reaction to medical errors, it was found that they solely are not primarily seeking money. Yes, we know there are those who will jump at the situation and want to seek compensation. but most of them, personally, even those I have interacted with, those that have lodged cases here, for them, it's just about that sense of justice. And that if someone had actually come before them and explained, they would not even be lodging a case. Actually, most file claims, not only because of the injury, but because of the subsequent insensitive handling and poor communication after the incident, where you become callous and you just try to turn a blind eye and say, you do whatever you want to do. And you don't even call to follow up and say, you know, I'm sorry, we can do 1, 2, 3 to rectify the situation. Overall, patients sued because of 4 thematic areas: to ensure other people do not get injured the same way. Patients did not get an adequate explanation of what happened. They want compensation, but for their injuries and medical bills, lost wages or cost of rectifying the error. That one is a major one that we usually see at the council, cost of rectifying the error. They desire accountability and someone to take responsibility for what happened. There are the implications of the word saying, I am sorry. It is yes, it is an apology and admission of guilt. And is it an acceptance of financial responsibility? There's no clear answer to this. It divides both us doctors and lawyers, because for us lawyers, when we are trying to see how we can settle the matter, we say without prejudice, so that whatever we've put in that matter cannot be used against us in law or in court. So for some in the legal field, they do see that apologizing for medical error is actually an admission of guilt, while others disagree. So the jury is still out on that. In one situation, a surgeon apologized after serious infection emerged near the patient's surgery site, prematurely confessing, we must have done something wrong. I'm sorry. Later, an infectious disease specialist determined that the infection had been present before the surgery even took place. But the jury sided with the patient because of the surgeon's early apology. We take that into consideration. However, the juries, when upheld trial, they admitted that they were sympathetic to the surgeon's situation, but they found his remark more convincing than anything the expert witness said. The decision was, however, overturned on appeal. So that is just something we should take into consideration. I know I have a minute left. So what should be done? The consensus seems to be more in favor of disclosure of the medical errors. Implementing such a policy is very problematic, I can assure you. Perhaps the legislation should actually see that how can we incentivize some of the physicians who actually disclose errors, or actually you're not seem to be put down for disclosing medical or surgical errors. Patients can already sue for negligence, but the penalties may need to be increased for physicians who are found guilty of negligence and did not disclose their mistakes to the patient, especially when there's evidence to show that they knew they had actually done a mistake. A different and preferable way to view such a system is that it rewards physicians who disclose all mistakes at an early point in time. Such a scheme would be comparable to how criminals can get a lesser punishment by pleading guilty at the outset and avoid trial, which is both costly and time-consuming for the judicial system. Preventing mistakes from occurring in the first place should be a top priority at every Kenyan hospital. Prevention is better than cure. In hospital settings, most catastrophic errors result as a result of systemic errors. Systems should be designed not just for purposes of increasing efficiency, but also for designed to reduce medical errors. But we understand when we speak of errors, is that fallibility is part of the human condition. We can't change the human condition, but we can change the conditions under which people work. So we can change the conditions under which people work to reduce the chances of them actually doing medical errors. Naming, blaming, shaming have no remedial value. So I think it's good that we need to design healthcare systems where we put safety first, so that medical errors do not occur. As I conclude, I just want to go back to the story of the lady who had her son admitted in a room with all the monitors blaring off, and she was trying to catch some shut eye and sleep. And the nurse had come and turned off the alarms. What this nurse did not know is that when she went and turned off the alarms, she actually turned off the alarms also at the nursing station and also at the pager. So when this child went into cardiac arrest in the middle of the night, nobody knew, no alarm was sounded, no alarm rang. As the mother was sleeping beside the son there, the son quietly passed on in his sleep. This was a medical error because even as the nurse was turning off the alarms to allow the mother to sleep, she actually thanked the nurse and said, "Thank you, at least I can catch some sleep." But because this nurse, when she realized what she had done, she went and apologized to this mother. This mother did not try to sue. This mother did not try to bring any court cases against her. And right now they're actually running an NGO and charity to try and show people that medical errors do occur, and with that we need to set up systems to reduce medical errors, and that we need to sensitize hospitals and practitioners to disclose medical errors when they occur without being defensive. Thank you very much.
Thank you very much, Mr. Michael, for that. It's been very enlightening, to say the least, discussing about the medical errors and the thin line between the medical errors and medical malpractice. We have already a couple of questions, but we'll get back to that after our last presentation. For now, we'll move to our second presentation from Mr. Kibet Kisorio from the Pharmacy and Poisons Board. Mr. Kibet, you can be introducing yourself as I put up your slides. Thank you.
Yes, good afternoon, everyone. As you've heard, my name is Kibet Kisorio from Pharmacy and Poisons Board. I'm the head of legal services. And thank you for inviting me to this conference. For sure, we are learning a lot of things in the field of health. So I would wish to share our experiences and generally see how we can, for the professionals, they can stay in practice and perhaps out of court. So that would be the highlight of my presentation. In terms of what we will be looking for is, I'd wish to address from what happens, because how I have outlined my presentation is, I wish to start from what happens when these things get caught before they come back now to the professionals. And then we see how, maybe, could we go to the next slide, please? Yes, so my outline basically is, we'll want to just the basic definition of medical legal issues, and then the legal principles on health professionals, because there are some aspects that whenever these things issues of medical legal issues, there are two things that courts will always look at, and even when it comes to tribunals, those are the basic things which are very critical for professionals. The issue of duty of care to their patients, and then the question of informed consent. I'll look also from the prism of when it goes to court and what is the practice. And then at some point, I'll take you to the legal framework on regulation of pharmacy, because I wanted to start from the topic of discussion, then go now to scope for the pharmacy field, just a highlight of the same. And then we look at the risk areas on the pharmacy professionals, some common areas which always brings issues. And then some bit of defenses, because we'll also want to look at if you are caught in this situation, what should be some of the defenses, because they always talk about the devil's advocates, so that have that at the back of your mind. We're not saying that you have these defenses so that you run away from responsibility, but it is good to know the other side so that always you're not got off guard. And then a few recommendations we'll be looking at in terms of what needs to be enhanced. Thank you. So let's look at the definition of medical legal issues. So basically, I don't want to belabor on this because I know it has been discussed all through and all through. So basically, there are medical cases with legal implication for the attending health professional. If you see my previous slide, the one with the photo, I think it gives exactly what we are talking about. You can see the law is there, and then tied with the stethoscope, which is a slogan mostly for doctors. So most cases involves injury, which investigations by law enforcement agencies are essential to fix responsibility regarding causation of the said injury or ailment, so that always whenever there's an issue, there will be this aspect of investigations, either from the professional body or when it goes to the other arms of government, they will always do the investigations. And then at the end of the day, there's the issue of fixing responsibility regarding the causation of the said injury or ailment, so that if it is a natural cause or is it human error. So to the next slide. Yes, so I'll also take you through the general legal principles, which for any professional, they will need to have at the back of their mind, especially when it comes to when these things get courts, and even the tribunals. These are always the guiding principles, which each and every investigation will just entails. There is a first aspect of duty of care. So in my presentation, I'll be looking at duty of care and with emphasis on the pharmacist, because from the pharmacy world, but it generally covers all the professionals in terms of what is the standard of duty of care we'll need to look at, and what normally the courts would look at when it gets to that point. And then the question of informed consent, because there is this special need and there is this special requirement in terms of duty of care, because you are actually dealing with somebody's life. So in issue of duty of care, when you come as a professional, this is an issue. It arises from the relationship between the health services provider and the patient. So this is such, we want to get to this situation whereby what do we mean by this issue of duty of care? So it is that relationship which arises from between the health services provider and the patient. And as you see from this court's decision, the courts observe that if a person holds himself out as possessing special skill and knowledge that he or she is consulted, he owes a duty to the patient to use caution in undertaking the treatment. So if you are a professional and you present yourself in such a way that you understand whatever the patient wants to, you have knowledge on what the patient is consulting, you have now, that is where the duty of care starts from, so that you have to use caution in undertaking a treatment or whatever services the patient is looking for. So basically, this duty of care arises at that point. So when does it arise? In this case of Ricardo and Njoki Wahome, this is the famous case of Wahome Mutai. The courts observe that a duty of care arises once a doctor or a health professional agrees to diagnose or treat a patient. Once you have agreed or to treat or diagnose a patient, that is where a duty of care arises. that professional, now you assume the duty of care to the patient. So it is important for professionals to understand where and when it stops, so that whenever they come to your clinic, whenever they come to your pharmacy, and you have once a patient, that is where, and you have agreed to do whatever procedure they want, that is when the duty of care starts from. So when we go to breach of duty of care, once if you breach the duty of care, that is now when it results to negligence, and that is where now the issue of medical legal issues arise. For negligence to arise, there must have been a breach of duty, which breach has been direct or proximate cause of loss, injury, or damage. So that once you've accepted that responsibility, and then the resultant effect, there should be some loss, injury, or damage to the patient. The standard of care is that expected of a normally skillful member of the profession in actual circumstance of the case. So that once, when it comes now to determination, what professionals normally look at is that what is the standard? What is the standard expected? You will not expect a standard of an ordinary person. It is, if you're a surgeon, what is the standard of an ordinary surgeon is expected to do in the circumstance? If you're a pharmacist, what is the standard expected of that normal pharmacist when a patient visits? So that is the standard which normally the courts and even tribunals look at. So next slide, please. The other aspect which comes into play is a question of informed consent. So in definition, it's acceptance by an individual, somebody who has to be to have mental capacity, and of course above 18 years, to receive treatment from a health professional. So that there is also that background check, which especially for a pharmacist, when they walk over to the counter with a prescription, normally, I mean, the first engagements, you have to gauge whether it is a very subjective test, but of course you can be able to tell somebody who is not mentally well. And then of course, age, you can also be able to determine the question of age to receive treatment from a health professional. A patient has the right to be informed of the risk inherent in the treatment, which treatment is proposed. So mostly, as a professional, of course, you have to inform them of, especially even for pharmacists, that issues of side effects, you have to really inform the patient and have a discussion on the same. So in this case of Sidaway, which is an all England decision, a doctor who operates without consent of this patient is saved in case of emergency or mental disability, guilty of civil wrong of trespass to the person, and he is guilty of criminal offense of assault. So that if you don't undertake that very critical background check, or if you don't undertake and make sure that you obtain that informed consent, whatever, especially for physicians, if you maybe do a procedure, it is as good as you'll be guilty of criminal offense of assault. I mean, it's like any other form of assault. So I think this aspect is very critical, because I know even for the other professional bodies, this is what, whenever you want to undergo any procedure, there's always this background check of that informed consent. So, and also whenever you want to undergo a procedure, now go back to the legal framework for pharmacy practice. So when we go to the pharmacy practice, we it's covered under Pharmacy and Poisons Act, Cap 244 laws of Kenya, which establishes the Pharmacy and Poisons Board. That is the board. And the board is responsible for regulation of health products, technologies, and the profession of pharmacy. So you'll see the issues of technologies have come through the medical devices. So that is why, because they are emerging technologies of the same, and now the aspect of the pharmacy profession, whereby the issues of medical legal now will arise, and that is why also the board also has a mandate in that. So Section 12 of the Act, which there's also an amendment, which the Health Laws Amendment of 2019, further enhance and widen the scope. And Section 12 establishes the Inquiries and Disciplinary Committee, that is famous as EDC, which is mandated to inquire on matters professional misconduct. So there is a whole procedure on launching of complaints, and then the tribunal, of course, will be constituted. And then, of course, also we are guided by provisions of Article 51 on rules of fair hearing. You present your case, the other side presents, and then all those considerations. So basically, that is what guides the profession. The constitution of EDC, and in terms of the statistics, because we also have statistics in terms of how many matters the EDC has been able to undertake, but largely depends on when there is a board, because the EDC is constituted by members of the board. So let's look at the risk. Some of the sorry, we could go to next year. The risk areas in pharmacy, because I want to limit to the pharmacy world. So some of the risk areas for the professionals. Yes, as I said, the roles of healthcare provider has undergone dramatic changes thanks to technology. That's why you'll also have, we have clinical pharmacy. There is a lot of area of specialization. So the most common risk area is the superintendent absenteeism. So there are many instances of superintendents being absent from their premises. You register, you have your premise, but you are working somewhere else. So you get somebody, some quack. So this is where, again, because registration involves giving a license, you have put all, I mean, when somebody works there, you can be able to see that this is a duly registered premise. But as a professional now, you're living to an unqualified person, and so that you go run other businesses or something. So that is the most, it's one of the risk areas, because when an ordinary member of the public walks in, of course you are in a lab coat, they always have this presumption that this is the person. And of course, when I give you the prescription, and then you might not tell this person is not qualified. So that is where the issue of duty of care will arise, because the other person believes in this other person that is duly qualified, but in real sense, this is not a qualified person, and the real professional is not giving the services that is required. The other risk area which comes also in pharmacy is failure to verify prescription or recommend if patient has or reconfirm, because sometimes there is this requirement that, I mean, always, you have a lot of these prescriptions coming day in, day out, but there is this important aspect whereby you have to verify and counter check it. Don't, because you will find most of these, some of the names even, they are almost similar. Or reconfirm if the patient has allergies, those things they normally ask, because for an ordinary mwananchi, we always think for sure that these people are just bothering you to ask, do you have any non-allergy? Do you react on this? So there are those common medicines which a pharmacist as a professional should actually be asking whether somebody can react to the common ones, which, and then there's also this important aspect of inquiring as a pharmacist in terms of if a patient is on medication. Sometimes there's the issue of breastfeeding, somebody is expectant. So there are those basic things that a pharmacist as a professional need to just cross-check and ask, because there are those which can be reactive. There are those medicines you cannot take with others. And then there is the other risk factor for professionals, especially in pharmacy field, is professionals engaging in creative and diagnostic services outside the scope of their training. So we've had instances of a number of pharmacists, um, especially those up country down there. They do curative and diagnostic services, and some of them they are not clinical pharmacists. They are not. I mean, in terms of whatever scope they are trying to do, they are doing basically what a doctor or a physician is expected. But sometimes you find such situations, and then things happen. Now a patient reacts, and then it becomes too late, and the patient says, "I thought this was a doctor." Kumbe. So there's that risk area, and then failure to give proper instruction to patient, especially on dosage, intervals of administration, because there are these very basic things which most of the common mwananchi think that they are so basic in terms of medicines. They're 1 times 3, because we have had instances of a lot of, at some point, you would hear people saying, you know, this medication was written 1 times 3. Then somebody goes out there, somebody asks the kids, like, what is 1 times 3? You get, it's 3, you take 3 at once. So there's that need to just remind the patient what the issue of dosage means. Uh, the other risk factor is also failure to ascertain existence of pre-existing conditions in patients, because those are also important background checks that needs to be done by a professional. And then the other aspect also is over the counter sale of prescription only medicines, because there are some medications that you need, they can only be given based on prescription. Defenses and liability, because we need to avoid handcuffs and stay in practice and out of court. Next slide, please. Some of the defenses that it's important for professionals to always have in mind is the element of negligence, because when it comes to medical legal issues, mostly it is an issue of negligence. And so when negligence to be proved, there is a duty of care. So did you have a duty of care? So some of the areas that you need to just clarify is whether there existed a duty of care, and what, as I explained earlier in my earlier slide, and that there was no breach, was the cause of injury, and of patient suffer injury.
The treatment guideline doesn't matter. So the reason why this is a really tricky one is because the word guidelines is used to refer to so many different types of experience.
Sorry? Yes. So the other issue is contributory negligence. As a professional, when things come to this end, there's a question of contributory negligence. For example, the patient did not follow instructions. So you might not actually, as a pharmacist on the other end, you might not, you have explained to the patient very clearly, and then the patient did not. So that is an aspect of contribution. And then sometimes the pharmacist, of course, was within the doctor's prescription. So it is something which is totally out of control, because, I mean, it is not, you gave whatever was the doctor had written in the prescription. So those are some of the common defenses when it comes to pharmacy-related offenses. So in terms of recommendations, the issues of drug review institutions, they need to create drug review institutions, because when it comes to reactions, there are a lot of scientific issues that come into it. So there is, well, if you look at the developed countries, they have drug review institutions so that they can be able to establish and guide on irrational drug therapy. The integrity of the system of professional self-regulation must be protected adequately. There's need to build capacity on rights and obligation of patients and health professionals. As Mr. Onyanga had earlier alluded to, there is that need to always explain to the patients, as health professionals. First of all, you need to know your rights and what are the rights of patients, so that you can be able to explain to them. Sometimes you also know your rights, and know that when you say I'm sorry, it's not you are admitting liability. And then there is need of proper record keeping by professionals, because I had said the issue of informed consent, those consent forms, all this documentation, whenever things go wrong, it is very important. So there is need and to remind professionals on the need to keep proper records, because sometimes these things come up after 6 months, 1 year. So there is always that need on paper trail, because that is what will actually explain what happened during the course of the year. So I think that should be the end of my presentation. Thank you very much.
Thank you very much, Mr. Kibet, for that enlightening presentation. We've learned so much from the presentation. Thank you very much. We'll have questions at the end of that presentation. Thank you, participants, for staying with us. We've already gone through medical errors by Mr. Michael Onyango from the Medical Practitioners Board and Dentistry Board Council. And you are now from having Mr. Kibet from the Pharmacy and Poisons Board. We'll now go to our third presentation by Caroline Mushina from the Nursing Council of Kenya. Caroline, you are welcome to introduce yourself further and to give us the presentation. Then we'll have the questions and discussion. Thank you.
All right, thank you. I'll be sharing a presentation from Nursing Council. My name is Caroline Mushina. I'm the Acting Corporation Secretary and Head of Legal Services. I won't belabor much on the issue of duty of care, which has been spoken about at length by my colleagues, Kibet and Michael. And I will limit my presentation to the nursing and midwifery practice. And we are saying that the council, that nursing and midwifery is guided by 4 pillars. We have the Nursing Council of Kenya, which is the legal arm or the regulatory body. We have the nurse and midwifery professional associations and the union, which is the welfare arm. And we have the training institutions, which are the educators and the Ministry of Health. And we are saying that these 4 must work together. The council is established under Cap 257, and it regulates the nurses and midwives, and it seeks to establish and improve the standards of professional nursing and healthcare within the community. And as a regulator, the primary objective is to promote best practice and ethical standards. Like every other professional, nurses and midwives are governed by codes and standards. We have the scope of practice for nurses in Kenya, which outlines the capabilities and range of professional activities that the nurses can undertake in Kenya. We also have the code of ethics and conduct, which prescribes the guiding ethical principles and the conduct expected of nurses. This also provides the responsibilities and accountability for what is expected of nurses, and it provides for nurses to undertake professional responsibilities and accountability. And particularly, it provides that a nurse carries personal responsibility and accountability for nursing practice and for maintaining competence by continued learning. The standards, we also have the standard of nursing education and practice, which prescribes the standards for nursing education standards, the standards of leadership, management, research, and ethical practice for professional conduct of nurses. This has already been defined before. We have what is malpractice. We are saying this is a careless, illegal, or unethical behavior by somebody in a profession or official position, which endangers the lives of the clients, the staff, the co-workers, the self, or environment. We have also defined what is misconduct, which we are saying is unacceptable and improper behavior. We have impropriety, which is behavior that is dishonest, morally wrong, or inappropriate in the circumstance, and also negligence, which has been largely talked about by my colleagues, which is lack of proper care and attention or failure to exercise proper care with regard to manner of discharging duty. When we limit ourselves to the nurses, in terms of the council's mandate on professional negligence, misconduct, and malpractice, we are guided by Section 18B and Schedule 1 of the Act, which grants the council power to sanction and make appropriate orders against or in respect to persons regulated by the council. And we have Section 18B, which talks about the inquiry by the council. This is a quasi-judicial process which is conducted by the council, where if the council receives a complaint or a statement from any member of the public and has reason to believe that a registered, enrolled, and licensed nurse or midwife has committed an act of professional misconduct, the council may on its own, through a committee appointed for that purpose, inquire into the matter. And we have the schedule or to the Act, which gives the procedure for inquiry. The procedure is such that we receive a statement in the prescribed form. Then there is notice for 14 days given out to the parties to appear before the committee. And the parties to appear have a right of representation from an advocate. During the inquiry process, an oath is administered by any member of the council or by the registrar. And the procedure that is followed is to the discretion of the council. And we don't follow the rules of evidence. We also keep a record of the proceedings. And if the person is aggrieved by the decision of the council, which is normally by the majority, they have a right to appeal in the High Court within 14 days of the decision being made. But we are saying we want to avoid the court and settle these things out of court. We are saying that on the completion of an inquiry, there are some rulings that are made by the council, and the council can decide not to take any further action or to reprimand the professional, the nurse or midwife, or that the professional pays to the council such a fine not exceeding 500,000 or as may be appropriate. There could also be a recommendation to undertake training at your own cost of such nature and duration as the council shall determine, and at such institution as the council may recommend. And we also have that recommendation that the nurse discharges their professional obligations under contractual arrangement, subject of the alleged misconduct, and any practicing certificates held be suspended, and a nurse could be deregistered from the register. My experience has been that in most cases, issues of malpractice or negligence, the council has normally recommended training at the nurse's cost, or the nurse discharges their duties under supervision, or in such gross cases, their license is suspended. I have not come across a case of deregistration or where a nurse pays a fine. We also have statistics, and as I had said earlier, the cases of negligence and misconduct are handled by the Discipline Standards and Ethics Committee. We have very few cases, but what the trend that is now, we are seeing now that more and more cases are being reported to the council. I think before that, most of the cases or the clients used to report to the medical council, but now the public and also, again, nurses are becoming more and more aware, and we are having cases, a lot of cases being reported to nursing council. What can we do to reduce the cases of malpractice? Number one is to ensure clear documentation of care is provided. Let us ensure that we document all care given to the patient, and we document all incidents that arise in the course of management of the patient. Our experience has been during the inquiries, what is verbalized, what our nurses tell us, or what the health professionals tell us is very different than from what is documented. And we say that what you say and you have not written, you did not do. And we are not even able to, our professional is not even able to provide evidence that they actually provided care to that patient. So the issue of documentation forms a major part of the issues that even go to court. Also, stick to your scope of practice and the context of the environment you are in. In the case of nurses, we have a specific scope for each cadre in the scope of practice for nurses in Kenya. However, we are cognizant that different organizations have specific mandates and limitations of what one can do and what one cannot do. So we are saying stick to the job description if you have, and if there is need to go beyond this, go beyond your mandate, you seek approval from your supervisor. We're also seeing a lot of persons who have not done their CPDs, who don't read widely. Most of them have no idea of what is happening currently on the ground. It's very theoretical. So we encourage professionals to read widely in your area of expertise, interact with colleagues locally and internationally, attend CPDs, there are online CPDs, so that at least you can match your knowledge with what is happening in the world. Also, mentorship is key. Mentor young professionals coming into the right nursing and midwifery practice. And this, I think, cuts across the board, all the medical professionals. Because when you mentor someone in the right way, they will hardly go out of it. But if you're mentored, probably not to even document or just to document patient or scene, that is what they'll carry on, even in the rest of their practice. And we urge young professionals to find someone whose ideas and practice they resonate with and they'd like to emulate. And this they will teach and keep you accountable. The other issue is communication, whether horizontally with the peers or vertical with the supervisors and managers. And you notify supervisors of situations which you are facing. And in my practice, I have experienced someone has a lot of burnout. They have been working shift. We know we don't have the appropriate ratios, but we are not able to communicate. So you end up going to work and you can't deliver much. And what happens, we experience some negligence, or maybe something just went wrong. It was not intended, but it went wrong because of the situation you are in. So encourage communication, notify colleagues and supervisors. If you do notify and you are not given time off, or whatever you asked is denied, at least have that in record. That again will also build your case when the same goes into litigation or you come to the council. We also have listening and soft skills. We major on the soft skills. Listen keenly to the patients and address their concerns. Our experience has been that dissatisfied patients are more likely to seek legal redress. So my colleague Michael talked about it. Talk to the patient, listen. Even if something goes wrong, they will say, at least so and so tried. And I don't think they will probably press charges because you'll talk, you'll apologize. But where you just don't listen to the patient, or you listen but don't hear, most of these cases go to court. And even the cases that come to us is like, nurse so and so was very rude to me, they didn't give me the proper care. The patients always have a conception of what, a conception of what they actually expect. And you as a nurse, if you don't read through and you listen to them and actually hear them, they might actually say that you are rude to them, whereas this is something that could have just been sorted by just listening and addressing their concerns. The other issue we would recommend, if everything goes wrong and you tried your best and we say negligence happened, whether it was intended or not, and you have appeared before the council or you have been taken to court, which we are avoiding, there is a recommendation to take a professional indemnity cover. The council it's not currently mandatory to take an indemnity cover in the council, but we urge those practicing in high-risk areas or in areas where the risk of negligence or malpractice or misconduct is high, to take a cover, so that if there was any negligence or impropriety, the indemnity will cushion the professional on the loss suffered. On this, I can give an example. We've had a few cases really where licenses have been suspended, and the professionals don't have any other livelihood, and say your license is suspended for a year, you cannot practice, you have no source of livelihood. The indemnity will at least cover that period when you are out and until when you are reinstated. And also even when you've been told to go and increase your knowledge and you go for courses recommended, which probably will take 6 months, which is probably full-time, and you don't have that kind of money to pay, most of the insurance will cover that. That's why we advise you can take a cover if you actually practice in a high-risk area. I think that would be my end of the presentation. I said I will not belabor on the issue of duty of care. Thank you.
Thank you very much. Thank you very much, Caroline Mushina, for that presentation. We now go to another session of Q&A session. And thank you, our panelists, for keeping the questions coming and for engaging us. Maybe we'll start with Mr. Michael Onyango. You talked to us about medical errors and about how we can use about the medical errors and how to go about them. There was a question about the difference between the adverse event and the medical error. Where do we draw the line, such that we may have a medical error that goes over to become a medical an adverse event, or is seen in a different way by the person litigating. Where do we draw the line between the two?
Thank you very much. Just to answer that question, a medical error is simply an error or a misstep in the treatment of a patient's ailment. So every known medical condition has a standard of care or a minimum level of treatment a patient expects from a practitioner, whether a medical practitioner or dental practitioner. If the medical professional or the medical practitioner meets the standard of care, but still commits an error due to an unexpected factors or factors beyond his control, he or she may not be guilty of any medical malpractice. So the difference, on the other hand, with regards to medical malpractice, it occurs where a medical professional fails to meet the standard of care. So in an error, you have met the standard of care, but something adverse happens, and something adverse happens. In medical malpractice, it is very clear that you do not meet the standard of care and that you are actually negligent, and that if you put a similar skilled professional in your position who was doing the right thing, the adverse effect would have been avoided. I don't know if that clarifies. So the difference between the medical error and the medical malpractice lies on whether standard of care has been met.
Yeah, yes, that clarifies it. Thank you for that. There is, just on the same note, there is a question on the medical errors caused by a failed health system. Just a comment about the errors that are beyond your area of practice or are caused as a result of a failed health system, or you don't have an equipment such and such. Yes.
Yes.
What is your comment on regards to this?
In law, we have what we call the reasonable man test. Just to explain this, with regards to negligent matters, that is what in tort law is that when someone does something, the adjudicator will ask themselves, would someone else of similar circumstances or similar situation, would they have done the same thing, or would they have done things differently? So I like to translate this to the reasonable doctor test, wherein if it is a doctor in, for example, Maralal, you would not be placed at the same test as a doctor in KNH. So we take into consideration the circumstances around you. You are a doctor, for example, you've been improvising for years for a particular procedure because you do not have the necessary required tools to undertake a procedure. But in line of improvising, something goes wrong. It's the reason why we have people as adjudicators, as judges, and as magistrates, because people are able to use discretion. There is black and there's white, but in the middle, there are gray areas. That is where now you bring in the discretion of the judge and be able to say, no, this doctor, he couldn't refer anywhere else. What else could he have done? And this lady died of postpartum hemorrhage. You, as opposed to, you're here in Kenyatta, okay, you're here in Nairobi, a lady is bleeding, and you didn't refer, and you still kept trying and trying. You didn't call to consult. So I hope that also explains that. So there are the systemic issues that are considered by any adjudicator. And even here at the council, when we look at cases, we take those issues into account.
Thank you for that response. I hope it's clear to the respondent. Thank you. We now have a second question to Mr. Kibet from the Pharmacy and Poisons Board. We have a question from Mr. from Kahura Mundia, long question in that regard. What is the standard of care expected from registered staff when delivering services where there exists no clear and express limits on the duty of care? So in this case, he asks about, for example, farm techs and pharmacists, case of CEOs, MOs, consultants, what is the standard of care expected from the same in regards to that?
Okay, thank you. When we talk of standard of care or duty of care, you see, when we are talking about a chain of, we have MOs, we have pharmacists, like any hospital setup, and we want to demarcate, because I think the question is actually, when there are a chain of, professionals, how do you demarcate now to say that this blame lies on this on a doctor or pharmacist or whoever? So it will go back to the issue of the test in terms of whichever the procedure that was happening, because if it is an issue of giving medicines, it is on the scope. If you are a professional pharmacist, what is expected, as my colleague had said, what is expected of an ordinary pharmacist when somebody brings a prescription to the pharmacy or a farm tech? This is number one. If you read the prescription, of course, counter check, and then such a thing. If it is a doctor, so if there will be a lapse, it can be, of course, it can be demarcated to say it happened. The doctor, of course, wrote the prescription, but when it got, for example, a doctor wrote a prescription, but sometimes even a pharmacist can tell this prescription you doubt because they have given two medicines which might not be compatible. So there is always that aspect of calling back. In the situation, you call back maybe to confirm because you are in a hospital setup. But that is, you are a professional and you understand the effects of the same. It's not that you are just like a shopkeeper when somebody comes with I want unga and what, it's just giving as it is. As a professional, when such a situation happens now and you want to demarcate on where does the blame lies, whenever you have a chain of professionals, it is you check on where did the lapse happen. If it is a theater, what was the professional acting in the circumstance of an ordinary physician would have done if it is a prescription which is brought to a pharmacy, and then how was the same conducted until if there was a lapse, or if actually it was an honest mistake. So I think the issue of demarcation and apportioning blame will come in terms of looking at what is expected of that professional in that setup. Thank you.
Thank you for that, on saying that it's in regards to the scope of work. And yes, maybe just a follow-up question. Who is liable to litigation? The doctor who prescribed or the pharmacist who issued the wrong medicines or the wrong dosages? The question that has come up before. Who is to blame in that case? What happens?
Yes, yes. Basically, if it is not very obvious, because as to what is obvious or not, it's different. But that's why I said in the circumstances, if it is generally a drug and then the pharmacist issues as been instructed, and then if a pharmacist issues and maybe maybe does not guide the patient on how to be administered, on how to take the drug, that could be, the blame could come on the pharmacist. But if the pharmacist does his or her work, but the doctor probably maybe prescribed a medication which could be reactive later or something, it might not, the blame might go back to the doctor who should have ascertained some of the things. So it is again a question of your scope. It's again a question of did you undertake the necessary due diligence in terms of, as a physician, what is expected of you when you are, like, before you prescribe, what is expected of you. As a pharmacist, on the other end, what is expected of you? Did you maybe counter-check a few questions here and there in terms of allergies and all those? Even the physician also is equally liable in terms of those other issues, in terms of just finding out. But blame will always be on the scope. That is my view.
Thank you for that. I think that's why we need to have multiple, what Michael talked about, multiple checkpoints before a drug is even issued. It has passed through several stages up to the dispensation. So when we review our systems, we may be able to catch this before it gets to the user. Thank you for that. I now have a question to Monica Muchama. From Monica Muchama to Caroline Machina. Maybe you will answer this for us. She's asking, a nurse in a district hospital decides to put an IV line in a 5-month-old baby instead of calling the intern doctor to do it. Unfortunately, she forgets the tourniquet, and this is discovered much later. By then, the infant's arm is severely swollen and gangrenous. To what extent, what is the extent of liability for the nurse, the doctor, the intern doctor, the supervisors of the institution?
Okay, I think the issue here would be to conduct the reasonable test. What would a reasonable physician in such a situation do? Did you do the multiple checks before you left the patient? Did you follow the right SOPs? And was it within your scope? Or did you communicate to your supervisor? I think that is what we will be looking at when such a case comes to the council. First, if a reasonable nurse in the same position would remove the tourniquet from the child, and there will be multiple checks, then in that case you will have committed a case of misconduct, and the responsibility, this will be on you.
Thank you. It's okay. For Michael, Mr. Onyango, we'll get back to you. On the issue of a disclosure of medical errors,
Yes.
there's a comment on regards to, from Kimani, we have a right not to share self-incriminating information. And there's also a comment on the same from Dr. Otieno. I am, where she says, when you apologize, when you're disclosing these medical errors, when you apologize, it could merely mean that you're empathizing with the misfortune and sorry for the inconvenience or whatever, but it doesn't mean that you did the wrong. So in the issue about medical error disclosure, many of our institutions don't have policies in regards to this as such. But in the issue of medical error disclosure, how do we go about it to avoid litigations?
Litigation. Yes, I understand. And if you saw in my presentation, I had highlighted that this issue has not yet crystallized, and I said the jury is still out there. But from what studies are showing is that when you come out and apologize and just show that this went wrong and I didn't do it, it was not on purpose, but the standard of care that I was supposed to give was met, but this is an adverse effect. We have seen that someone is less likely to lodge a case. Not that they won't, okay? They are less likely. And that's why I said, maybe it's high time that the health sector is provoked by this line of thinking, maybe even those who write our laws, that maybe if a doctor who discloses at the early onset when they realize something has gone wrong, that they are not found, even if, and later when they go through the whole process and they are found culpable, for example, maybe the sentencing is less. And if you actually disclosed early that you are not, whatever that disclosure is not used against you. We lawyers are very good at that. When we're trying to interact with each other, when we are trying to settle, we are not gone through the court process, we use the word without prejudice. That, okay, I know we had a disagreement, but without prejudice, how can we sort this out without going to court? So that's just the line of thinking that we have, because the number of cases, for example, we get at the council that could easily have been sorted out by saying, I'm sorry, or this happened, but it is an expected complication of this, this procedure. It would have saved you a year or two of back and forth of coming to the council, of being called for hearings that you would otherwise not have been put against. So that is my response to that. But we probably do need to work on how to safeguard practitioners who just genuinely make errors.
Thank you for that response. Maybe still you could answer this one. What is the caveat on duration of a legal complaint? Is there a caveat on duration a legal complaint can be forwarded to the regulatory body?
Well, yes, because from what we find is that you're actually supposed to keep documents with regards to patients for maximum, I think, of 7 years. So beyond 7 years, it's very difficult for even the council to be able to interrogate a particular issue. But in law, as per the Act, since we actually regulate the profession, we don't see it as strictly as the High Court does, with very strict rules and very strict timelines. The council sits more as a quasi-judicial entity, which in other terms is an inquiry, where even your peers or your seniors come to look into your conduct. So for the council, we have settled on not more than 5 years. You can't, it becomes very difficult to investigate a case that has occurred more than 5 years ago.
Thank you for that. And maybe just another one before we give over to Kibet. Where is the line? Okay, there's a comment or a question here from Kihara. Elaborate on when the duty of care starts and ceases when a patient presents for emergency care, as per that stated in the Constitution.
Come again?
Okay. Elaborate when the duty of care starts and ceases when patient present for emergency care, as per that stated in the Constitution. I guess here we are talking about there's usually a gray area when the patient needs emergency care versus what you can be able to provide at that time, or when then, for example, they're not able to pay and they need the emergency care. It brings about a legal question.
The issue of emergency care and payment. One of the major issues when the Constitution was being reviewed was with regards to access to healthcare, particularly with regards to emergency care. If you look at the Health Act, Section 7, it actually breaks that down. And the whole idea is this: when a patient presents to your institution and needs emergency care, remember, emergency care, they've not gone into consultation rooms, they've come through A&E, and it's very clear that this patient needs emergency care. You give it. Regardless of the circumstances, the Constitution says that if someone presents and they need emergency care, you give it without thinking, you give it without asking for money. You stabilize the patient because a patient's life supersedes any other commercial interests. If at all, after stabilizing the patient, and the patient is not able to meet some financial aspects, you refer. So you don't hold them and try to tell them, for you to be admitted, lazima ufanye hiyo, lazima ulipe hii deposit. You don't do that. You refer. However, emergency care, the Constitution does not negotiate on that because of the aspect of the sanctity of life. You give the required emergency care. If there is more definitive care that needs to be given, you give it. But if you cannot do so, refer. Thank you.
Thank you for that. If you're not able to give it, just refer and have the necessary explanations and documentation. Thank you for that. We'll now go to Kibet. Mr. Kibet, there is a question on what is your take on over-the-counter prescription. At the same time, we'll combine it with this question on clinical pharmacy, whereby pharmacists do study clinical pharmacy, which provides knowledge sufficient to diagnose common ailments. We have pharmacists trained even as vaccinologists, and there's a comment on there needs to be reforms in regards to that. So what is your comment? What is your comment in regards to over-the-counter prescription and clinical pharmacy?
Okay, in terms of over-the-counter prescriptions, the OTCs, basically, you see, these are things which a patient will always come, and then you can just dispense over the counter. But I don't know in terms of what is the inquiry about it, because over the counter will it is allowed to be sold over the counter as they are. I don't know what could be the question from because my take on over the counter is of course there should be when a patient comes to you, even if it's an over the counter medication, as a professional, because all these things goes down to the professional in you, so that there is that aspect of that interaction, professional, because you see, when it comes to pharmacy, it should not be seen like shopkeeping. You are just selling, you just come by Omo, you are given. Pharmacy is more of, you give that professional advice, even if it's over-the-counter medication. You know, people have assumed that when you just have some migraines, some headaches, you just go and buy Panadol and just go like that. But for when you find a professional, they will always want to inquire, okay, what is the issue about? Then you're like, I have some headache. Have you consulted a doctor? Have you taken some water? The common therapies before even, and somebody might even decide, okay, I think I've not been taking enough water. Let me just go take some water. So if, in my view, in terms of, I don't know what the person asking the question wanted to be addressed, but I would say that over-the-counter medications should not be seen as just over-the-counter in terms of coming to buy, like shopkeeping. It should also have a professional touch in it, so that you come to the counter as a professional, try to guide the patient. Don't always assume, because sometimes somebody could be having a continuous headache and he's just buying some paracetamol. You think that they're just going to take that. Kumbe he's decided he wants to take like of them now. He's been taking 2 and he's not feeling anything. Professional, whether over the counter. Oh, sorry. There is a
Yes, we can now hear.
Yes, there was a second limb. There was a second limb of your question. What was it again? Sorry.
Yeah, yes, it was in regards to the clinical pharmacy. The scope.
Specialties. Yes.
Yes.
There are those specialties. Number one, which is very important, is that for professionals, it is important, first of all, to also register with the board, because the board nowadays, there are guidelines on specialty pharmacy. So if you want, number one, if you want to specialize, it is important you first of all register with the board. There are regulations on our website you always follow. Then you register as a professional in whichever field. And then number two, you will now be guided by the code, because what we are getting from all these professionals, even cutting across our presentations, there is a code guiding each and every aspect. So what is important is for everyone to stick to their lanes, so that you don't, even if you're a clinician, there is a scope or there's an extent you can go. You don't, once you convert to a clinician, it's not that you are now becoming a physician. They operate within your lanes. There are guidelines on and the code, and which as a professional they're supposed to stick to. Thank you.
Thank you for that. We'll now we have a question for you now, Caroline. I can ask you. Whereby just a comment on informed consent for minors in regards to where they need procedure. This is a question that always comes up in our legal presentations. Where is the line? Where do you draw the line when you're getting consent for minors, where they need procedures done or emergency care done? Maybe you can start with that one. Yes.
Okay, thank you. For informed consent of minors, I think I'm losing you. I have problems with my connectivity. Just a minute.
Hello, Caroline. We may have lost her as we wait for her. Maybe Mr. Onyango, you can give a comment on that.
The informed consent of minors. Yes.
Yeah.
Just to give an answer to that, generally minors, that includes entails those below the majority age of 18 are not able to enter into certain binding agreements. So for a minor, by law, they have what they lack what is called capacity. So I can see Caroline has joined in, but I can just finish my comment. So that is why when you're seeking informed consent from a minor, it can't really work, because it has to be done through a guardian. That's why there's usually the parent or guardian. It is that parent or guardian who has actually attained that majority age of 18, who does it on behalf of the minor. Because a minor, anyone who's below the age of 18, does not have capacity to enter into any agreement or contractual obligation. But yes.
Thank you. Caroline, you want to comment?
Sorry about that. As Michael has said, a minor is a person who has not reached the age of majority. Therefore, they lack capacity to enter into any contractual or legal or any binding agreement. Therefore, their consent should be obtained from their proper guardian or parent or this can be biological or adoptive parent, but there needs to be proof that this person is the guardian or the parent or the biological parent or the adoptive parent. So we cannot proceed on any consent given by a minor. The law does not even allow you to enter into any agreement or anything with a minor.
Yeah, just maybe to add on that, to add on that, what is important in this consent is it has to be not verbal consent, because I had seen a number of cases. If you look at even what has gone to the high courts, you will find that sometimes somebody says, yes, I told the mother and the mother accepted. And then, so what is important for professionals to remember is the issue of documentation. Ensure that you keep a record, let them sign or put any indication and having fully been explained to. And the other aspect, which I think also my colleagues have stated, is whenever it's a minor, again, circumstances also dictate in terms of if it is an emergency situation, cutting across. Emergency situation, the adult is still far away and there's an operation that needs to be done immediately. That is where consent is defeated in some situations. But again, for a professional, make sure you document. There's importance of documenting these things so that it be known. If you call even whoever is the next of kin, let it be known that they are far away. Let them, it is important you keep records. Thank you.
Thank you for those comments. And maybe just as we are on that note of documentation for Kibet, for Mr. Kibet, where do, in terms of this era of COVID has seen things go through the internet. You're using now the internet to do most of our documentation, or most even of these medical errors. What is your comment in regards to the same on the use of the internet, and where the information, there are dangers of using the internet? There are pros and cons. Even as we try to make our systems better, there are pros and cons of going digital. So what is your comment in regards to that?
Yes, well, for sure, we are in very uncertain situations, but the issue of innovations will always come in. For example, now we are having all this meeting with around 600 people, and everybody is in their offices. So number one, when it comes to that, in terms of documentation, there are various innovative ways of addressing this, because when you want to seek consent, there can always be innovative ways of, because we even have up to the issue of electronic signatures, whereby you can always scan on the other end, then they can always send. They can even, you've seen, even the courts have been flexible nowadays. They accept even those scans or screenshots. So what is important is for a professional, make sure that you have that contact, you engage the person on the other end from whichever means. For now, if you are in remote areas whereby you have problem with internet, they can always, even, because what is important is to have something you can fall back to, because you see all these medical legal issues, whenever things happen, the patient will always apportion blame to the professional. So what we want to urge professionals is always, even if you are in a very hard situation, and there are innovative ways, ensure that maybe if they are on the other end, they have, or even WhatsApp, they can always write something and then let them scan to your end so that you have something. Because if you only have verbal communication, that is where you might learn problems. Because let us remember, the patient will always, they are in desperate situation when they are unwell. But when things go south, the professional is the one to be blamed always. They will always now start blaming you, saying, you didn't do this and this. So there's need for professionals to be innovative. We are in COVID situation, let us be innovative enough and have something to fall back to. Thank you.
Thank you for that.
Just to add on that,
Yes, please.
we're in unprecedented times, and as my colleague says, that we have to innovate. But just to safeguard yourself, as you innovate, just the underline the principles that you cannot deviate from. With regards, for example, informed consent. Informed means actually informing, not just saying sign HAPA or sign here. It's actually informing and then getting consent based on that, the information that you've given. Then the other issue is documentation, as my colleague has stated. The law does not consider what you feel or what you know, it's what you can prove. And what you can prove is what you've documented. If you've not documented, however much you know you did this procedure, but you didn't document it, it didn't exist. It's not what you know, it's not what you feel, it's what you can prove.
Thank you. Thank you for that comment, for those comments. Indeed, you need to document, even where we have to have in hand what you cannot do, what you can do, so that you explain the circumstances within which you practice, just as we were told last time. We'll now have thank you our participants for staying with us, for engaging us in the Q&A question. We'll maybe have just a few, Mr. Onyango, Michael, this one is for you. We'll start off with this. We have had cases of governors ordering closure of hospitals when the media airs a case of assumed negligence. So what is the take of the regulatory bodies, and does the law allow for this?
Okay, yes, well, thank you for that question. The whole, I think that whole issue comes about as a result of Constitution of Kenya 2010, particularly under Schedule 4, which split the roles of the national government and the county government. Where some, maybe some governors might feel they have more powers than they should, or they might exert what they might not necessarily have powers to do. Because with regards to regulation of professional issues or misconduct, that power is vested in the regulatory bodies. So it is for the regulatory bodies to adjudicate over that matter and go into it. However, when it comes to closure, it's just like, that's the reason for a person being arrested, is so that you're not harmful to others in society. And then maybe once we've been able to sort out the situation with you, you'll be released out on bail. So sometimes it is just to arrest the situation. You said, okay, first let's get everything in hand. Let's assess the situation. Then you can say, okay, fine, this facility can go on to offer services. However, in this unit, you can't offer services until the whole inquiry process is complete. So that ideally should be done by the regulatory bodies.
Maybe to add on what my colleague has said, there is the overriding public interest also when it comes to, maybe especially, I think the person asking the question is regards to these media hyped investigations, and then what happens. So I think, again, sometimes it comes to public interest, as Michael had said. There is need to safeguard public interest, and then they intervene. As you know, there is a role of professional bodies in terms of actually closing and doing all those things. But you know, sometimes when these hyped reports are reported from the media houses, it becomes even risk even for them to continue operating. So there is need to safeguard public interest when they come and close, but it should not be abused. There's a very thin line also, because sometimes there is a small investigation and then they close entire hospitals around each and every place. All pharmacies are closed because they're saying, oh, they're conducting all these abortions and all those. So there is need also to balance, because when it's left to politicians, they would always want to please the public that we are doing something. And then they go around closing all these things. Even the public might not even tell who is the regulator. So there is need actually for professional bodies to continue being left to do their work. But sometimes public interest will always call for these drastic actions.
Thank you for those comments. Just have two more, then we'll do a roundup. Maybe Caroline, you can answer for us this one. There are still questions in regards to the scope of the healthcare workers practicing. We have a question here from Kimengich, whereby he's asking, is it medical negligence or malpractice when one practices, when you have these other cadres or paramedics practicing medicine, and there occurs fault, or there occurs litigation in regards to the same. Let me just come again on that. He's asking, there are those paramedics from other cadres, instead of doing the line of job description, they go and perform a procedure which or she has not trained for, then something goes wrong. So in this regard, who is this a malpractice or negligence on their part, or it's the supervisor who takes the blame? And yes, maybe you can go first on that.
Okay, thank you for that. I'll start approaching the question from, there are many, right now there's a lot of development that many of the roles that are being done by, maybe I say doctors and pharmacists, are being even taken up by nurses and maybe pharmaceutical technologists. They have widened their scope. Now, when they have widened their scope and you are actually allowed to conduct such procedures, then you have a duty. And remember, you carry a personal responsibility and accountability to maintain competence, and you continue learning and updating your competencies. And I think what we need to do is ensure that you are well informed and you actually work within your scope. Then in that case, when an issue of medical negligence or an error happens, you will be within your scope. But if you just let's say you're doing your scope is limited probably to just seeing patients, and then you go on and do something else that is now out of your scope, that is really gross negligence. And I think with that you can the liability is actually very high on you, given that you have done something that was not within your scope. I mean, even as a regulatory body, we cannot consider that you tried, or it's something that was, I mean, a reasonable person could have done, but maybe you missed out on a few things. But if it's a new thing really that you jumped into it and did, and you are not allowed, then in that case you have I mean, it's gross negligence.
Maybe to add on that, when a case comes to the medical council, the first question we'll ask is, Dr. Agnes Karingo licensed? Yes, she's licensed. She's licensed to do what? So if you're not licensed, we will not even go to the merits of the case, whether you did the right thing or the wrong thing, or the reasonable doctor test, or whether you are actually, the working environment was not proper. It's like you do not have a driving license and you get involved into an accident. Regardless of whether the person who hit you was on the wrong, the first question the policeman will ask is, where's your driving license? If you don't have a driving license, you shouldn't even have been on the road in the first place. Then with regards to your license, what does your license permit you to do? If you see your driving license, it has various categories, category A, B, C, D, from motorcycles up to the 32-wheeler trucks. If you're not licensed for all this, you are driving a truck when you're only licensed for a saloon vehicle, you become liable. So if you are a paramedic and you're there trying to do a surgical procedure, you are the one who's going to be held liable.
That is clear, it's very clear, and I hope for our attendees we've been able to capture that. And for the questions in regards to the scope and in regards to the healthcare workers, the different roles, that one has been clearly answered. Thank you, Patricia Otieno, for your comment. I'm able to see that even despite the trainings, we still have reluctance to take up these roles because of the consequences that come when medical negligence is brought up. So for now, we'd like to come to a close of our session. We want to thank our panelists for being with us and for taking us through these sessions. We've had Mr. Michael Onyango from the Medical Practitioner Dentist Council, taking us through medical errors. We've had Mr. Kibet Kisorio from the Pharmacy and Poisons Board, and we've had Caroline Mishina from the Nursing Council of Kenya. We'll have them give us their parting shots, even as we come to an end. We'll start with you, Caroline Mishina.
Okay, thank you for the opportunity. I can see there are many other questions which probably we would have wanted to address, but maybe because of the constraint of time, we are not able to. Maybe we can respond to them offline, because I think they are quite important, and we need to make clarity. And then again, I am happy that we have a lot of participants. We want to understand these medical legal issues. They can be difficult, but once they are demystified, I think we will not have a problem of professionals shying away from taking up roles, fearing that there may be issues of, medical legal issues coming up. I think we should be confident. We are there to support and guide. And where someone is not maybe comfortable in handling something, they can always reach out to us. We can give legal advice. I have not shied away from giving a person advice when they come to me for any issue, because they want to enhance their competence and skills. Thank you for the opportunity, and thank you for the attendees and their questions.
Thank you, Caroline. We are glad to have you. Mr. Kibet Kisorio.
Thank you. I would also wish to thank the organizers for having us. For sure, especially having us from the cross-cutting spectrum, there's a lot of things we are learning. And if it was a physical meeting, I'm sure there would be a lot, and we would have a very long session. But nonetheless, we thank you for innovating. Thank you. We are learning, and also the questions. I think we will take time to just distill some of the issues and see how to respond, and even they also inform our policy and even the in-house things of our bodies. So the other issue, I would wish to just urge the professionals who are in this forum that, number one, it is good to stick to your profession. Let us know the limits where we are supposed to operate. Let us stick within the codes of conduct. There are situations out there which sometimes you would wish to just do because you are trying to save a life and all these things. But I would wish to urge the professional that important, number one, stick to your line, document all this information, and always inform the patient, because if things go south, all these patients, they will not, they don't take into consideration what you are trying to do, because this is somebody who is trying to get closure. So always stick within your lane, because you have to cover your back. You need your practicing license, because if that is taken, now you are good as any other person out there. The last thing is always be in good standing with your professional body. Because as my colleague had stated earlier, whenever things come this side, if you want to stay out of court and within the profession, it is good if you are, first of all, a professional, because at least you will be dealt with by your peers, as opposed to going out there to court. Because if you are not, what Michael didn't tell you, if you are not, now it becomes a criminal issue. It goes out there, it becomes a criminal case. So it is important for professionals to always be in good standing, because you have your home you can always run to, and they will always be there to guide you. Thank you very much, and God bless you. Thank you.
Thank you, Mr. Kibet. Glad to have you, Michael.
On behalf of the CEO of the Kenya Medical Practitioners and Dentists Council, thank you for inviting us and giving us this opportunity to share as the regulators of doctors and dentists, community health officers and of institutions about staying in the practice and out of court. My parting shot would be, when you treat, document. When you don't know, consult. And where you can't do anything, transfer or refer. But in the end of it, document, document, document. It's not what you feel, it's not what you know, it's what you can prove. Thank you very much.
Thank you very much for that. We have now come to the end of our session. Indeed, we've not been able to answer, we've answered majority of the questions, but we've not been able to cover everything. And just because this is a wide discussion, we'll have another session coming Wednesday. We'll have another session coming Wednesday where we'll still delve more into the medical legal issues. So please do join us, please do engage us, and we'll be able to know how to stay in the practice and out of court. Maybe in our next session, we'll also have a session on our rights as medical practitioners. I think there are comments here on how even the Kenya police rush to harass us. So where are our rights? Where does the buck stop? So we'll have all those discussions coming up in our next session. Thank you very much. You are welcome to join us in the coming week, where we'll have a discussion on evidence gathering. This is an extended session that we've just put up because of the many discussions that have come up during these last sessions. So thank you very much. Have a good afternoon, good evening. Thank you.